Welcome to AudioCert, where the official study guides are brought to life. Welcome to the deep dive, where we take your source material and distill it into essential knowledge. Today, we're diving into, well, a really crucial area for anyone serious about cybersecurity, the legal landscape that governs our digital world. Specifically, we're exploring Chapter 18, Appendix B, of the EC Council Computer Hacking Forensic Investigator Certification. That's the 31249. It covers worldwide forensics acts and laws. For you, our listener, whether you're aiming to be a certified hacking forensic investigator, a CHFI, or maybe you're just curious about the intricate legal guardrails of the digital age, this material is absolutely vital. It's really about understanding the rules of engagement, knowing how to protect digital evidence, and ultimately how to ensure justice can actually be served in the face of these ever-evolving cyber threats. This isn't just theory, it's the foundation for every ethical and effective investigation you might undertake.
That's exactly right. Our mission today is to equip you with a rock-solid understanding of these legal frameworks that govern digital forensics globally. You see, when we talk about cybercrime, we're often dealing with something that's inherently borderless. You could have a hacker in one country attacking a server in another, affecting victims, well, all over the world. And yet, the law, traditionally, is very much tied to geographical boundaries. It's a fascinating tension. So we'll navigate this complexity by exploring the core legal distinctions that really matter to you as an investigator, common types of cybercrime and how they're legally addressed, and importantly, the international efforts trying to create a more unified front against digital wrongdoing. Think of it as a guide to understanding the legal playground where all digital forensic investigations take place. It should give you the confidence to operate within its rules.
Okay, let's unpack this then. The source material jumps right in, letting that electronic law is very complicated to confine. Now, when I think of traditional legal fields like, say, contract law, they feel somewhat self-contained. So what makes electronic law so uniquely complex? What's the core challenge here?
Well, what's truly fascinating, I think, is that electronic law isn't really a single isolated field you can just point to, like contract law or tort law. Instead, it's much more like a vast, interconnected network itself, touching upon and often challenging many existing legal disciplines. It crosses over into criminal law, civil law, intellectual property, privacy, and so much more. The complexity really stems from how digital interactions fundamentally reshape the application of laws that have been around for, well, a very long time. They're forcing these laws to adapt to scenarios their creators could never have imagined. It's less about creating brand new islands of law and, I guess, more about a powerful digital current flowing through all the existing legal rivers, stirring everything up.
That's a fantastic analogy. So it's not a new legal island, but like a force that reshapes the entire legal landscape. Building on that, then, does this mean cyber crimes are fundamentally new types of crimes, or are they just, old crimes committed with new technology?
That's a really important question, and in most cases, it's the latter. It's old crimes, new tools. Think of identity theft, for example. It's existed for centuries, right? The internet hasn't invented identity theft, but it has drastically increased its speed, its volume, and its effect. I mean, imagine the difference between someone physically stealing a letter from your mailbox versus, say, a phishing scam that can compromise thousands of accounts globally in just minutes. The core criminal act, taking someone's identity, is the same, but the medium and the sheer scale are, well, entirely transformed. So for you as a certified hacking forensic investigator, a CHFI, you're often looking at familiar criminal intent, but it's manifesting in these unfamiliar digital ways.
That makes a lot of sense. The tools change, but human nature, unfortunately, often doesn't. But you mentioned new challenges from networks. If cybercrimes are mostly old crimes with new tools, what's genuinely new? What unique hurdles do these widely distributed networks like the internet throw at us that we never really had before?
That's where it gets truly interesting. Widely distributed networks, just by their nature, allow for actions that completely defy traditional geographic boundaries. So how do legal systems respond? Well, some jurisdictions choose to mend existing laws, sort of adapting them to the digital context. They might update definitions or expand interpretations to include digital acts. Other jurisdictions, though, they create entirely separate digital laws, adding specific computer crime statutes right into their criminal codes. And this patchwork approach, where some countries tweak old laws and others write completely new ones, is a significant part of the complexity you asked about initially. It means a single cyber attack could be viewed through entirely different legal lenses depending on where it's being prosecuted. And that creates a minefield for investigators like yourself.
Yeah, I can definitely imagine that makes it incredibly challenging for a forensic investigator trying to navigate all these varied legal interpretations. You also highlighted a common source of confusion, the distinction between what is illegal and what is criminal. Can you elaborate on that? And maybe more importantly, why is this distinction so crucial for someone like our listener, a CHFI, working with digital evidence?
Absolutely. This distinction is critical, and as you noted, it's not unique to electronic law at all. Many actions are illegal, but not criminal. Think of a high-speed car chase. The driver is committing illegal traffic violations, right? Those are unlawful actions. Now, contrast that with something like murder, which is clearly a criminal act. Both are unlawful, but one leads to state prosecution, often with severe penalties like imprisonment, while the other typically leads to things like fines, license revocation, or maybe civil penalties.
Okay, so the consequences are vastly different.
Hugely different. And for you, as a forensic practitioner, this distinction is paramount. Why? Because the evidentiary requirements in criminal cases are far, far stricter than in civil litigation. In criminal cases, the burden of proof is beyond a reasonable doubt. That's a very high standard to meet. In civil cases, it's usually a preponderance of evidence, which basically means more likely than not. However, and this is absolutely critical, the standards for handling evidence should be equally high in both types of cases for you as a forensic practitioner. You want your evidence to be irrefutable, meticulously documented, and legally sound, regardless of the legal context. A single error in your chain of custody or analysis could potentially sink any case, civil or criminal. It's all about maintaining the integrity of your work, always.
That's a really clear analogy, and the emphasis on consistent evidence handling, regardless of the legal type, is a powerful takeaway. So when we move into the actual legal proceedings, that distinction between criminal and civil law dictates everything from the severity of potential outcomes to how evidence is scrutinized. For a forensic practitioner, what's the fundamental difference between these two areas, especially in terms of how their work gets applied?
Well, at its core, a criminal case generally involves the state punishing an individual for undesired behavior that is believed to harm society as a whole. The goal here is punishment, things like imprisonment, significant fines, or other state-imposed sanctions. The state initiates the action because the crime is seen as an offense against the public. You often hear it phrased as the people of the state of X versus John Doe.
Right, so the state is seeking justice for a societal wrong.
Exactly. A civil case, on the other hand, revolves around a person or a company seeking to recover damages or maybe stop specific behavior from another party, perhaps through something like an injunction. The goal here is compensation or a remedy for a private wrong, not punishment by the state. Think of it as a private dispute where one party seeks to be made whole for harm caused by another, like a breach of contract or maybe personal injury lawsuit. Your digital forensics might be used to prove financial losses or demonstrate a specific action by one of the parties.
And this directly impacts how a forensic investigator's findings are used. In criminal law, you mentioned two foundational pillars, actus reus and mens rea. Those sound quite formal. Can you break them down for us and maybe give us a quick digital example for each?
Certainly. These Latin terms are fundamental to proving a crime has actually occurred. Actus reus, which translates to the guilty act, is the physical element of the crime, the actual act committed. It's about what the defendant physically did. For example, in a hacking case, the actus reus could be physically sitting at a computer and launching an attack script, or maybe configuring a server to send out malicious code that disrupts the system. It's the tangible, observable action that violates the law.
Okay, so actus reus is the doing part. Got it. What about mens rea? Does that mean the criminal also has to be like a supervillain with a clear evil plan?
Mens rea, or the guilty mind, is the mental element associated with the deed. This is more commonly known as intent. Sometimes, though, recklessness can suffice if specific intent is hard to prove, so no, it doesn't always have to be a supervillain level of evil. Let's take that hacker example again. Hacker bragging about an impending site breach over, say, an internet relay chat IRC channel, detailing their plan and motivation that demonstrates clear intent, or mens rea. They consciously decided to commit that act and knew it was wrong.
But what if it wasn't so clear-cut? What if someone makes a technical mistake that causes harm, but they genuinely didn't mean to? Could a penetration tester, for example, accidentally cause a breach?
That's a fantastic point, and it's where your skills as a CHFI really come into play. Consider a penetration tester who's hired to test a client's systems. If they unknowingly attack a site that doesn't belong to their client, but they genuinely believed it was their client's, well, this scenario highlights the importance of proving the mental state. If they didn't verify the address properly, they might be considered reckless, which could still lead to legal consequences, depending on the jurisdiction and the specific facts. However, if you can prove they acted in good faith, believing they were within the scope of their authorized testing, they could potentially be shown to lack the specific criminal intent required for certain offenses. This distinction between intent, recklessness, or even just a good faith error is critical in determining culpability. And your forensic evidence helps paint that picture for the court.
So it's not just what was done, but why or how the person was thinking when they did it. That's a huge difference, particularly for a forensic investigation trying to establish those motivations. Now, switching over to the civil side, you mentioned contracts and torts. Can you elaborate on those, again, with a focus on what a CHFI might encounter?
Of course, a contract is essentially any agreement where there is an offer, acceptance, and consideration. Consideration can be monetary, or it can be anything else of value that is exchanged between the parties. And in the digital age, electronic communication like emails, instant messages, even clicks on a terms and conditions box can absolutely form binding contracts. For a CHFI, you might be called in to determine the origins and scope of contractual dealings by recovering emails or saved documents, or maybe examining server logs to establish precisely when an offer was made and accepted. Did person A actually click I agree on a specific date? Was email B really sent from sender C? Your evidence becomes crucial in settling these disputes.
So an email exchange about a business deal that goes sour could become critical evidence if it ends up in a civil dispute.
Precisely. Then we have torts. Torts are civil wrongs that involve violations of personal, business, or property interests where a reasonable person should have foreseen the impact from their imprudent actions. It's really about a duty of care that was breached, causing harm. It's distinct from a contract because there might not be a direct agreement between the parties involved.
Can you give us a digital example of a tort that a CHFI might help investigate?
Certainly. Let's imagine you allow Bob to host his website on your server. You haven't given him any specific authorization beyond just hosting the site, but then Bob uses your server to send out massive volumes of unsolicited email, spam. This leads to your server's internet protocol, or IP, address being blacklisted, causing significant downtime and maybe reputational damage for your business. You could potentially sue him for damages under the tort of conversion because he used your property, your server and its resources, in a way you did not anticipate or license. He essentially converted its use without authorization and caused you harm. Your forensic analysis would be key to trace those spam emails back to Bob's activity on your server.
Ah, okay. And just to clarify, if you had a formal agreement where Bob paid you for the server space and he misused it by spamming, that would be a breach of contract, right? Not a tort.
Exactly right. If there was an explicit agreement outlining the terms of use and he violated those terms, the legal action would arise from the violation of that contract, rather than just the unauthorized use of property in a general sense. The distinction really lies in whether there was a pre-existing formal agreement defining the expected behavior.
Fascinating how those distinctions are drawn. You also noted that forensic professionals sometimes gather information for cases that aren't strictly legal actions, but still matter significantly to an organization. What kind of situations are those?
Right. These often fall under the umbrella of internal investigations. We're talking about situations involving, for example, material that is highly offensive, but not technically unlawful. Maybe it violates company policy, but isn't a criminal act per se. Or it could be a clear breach of internal procedure or policy that doesn't violate a specific law, but definitely contravenes company rules. Or perhaps just simply inappropriate behavior that falls short of being illegal, but is still detrimental to the workplace environment or the company's culture.
So things that might get someone disciplined or fired, but not necessarily arrested.
Precisely. Think of it this way. In many places with at-will employment, an employer might seek to minimize risk by removing an employee who was the source of that risk, even if no actual legal wrong was committed. Your forensic evidence, such as logs of inappropriate website visits or perhaps internal communications, helps the organization make informed decisions about disciplinary action or termination, even if it's not destined for a court case. The standards for evidence collection should still be just as high, though, because reputations and livelihoods are definitely at stake.
Absolutely. Now, here's where it gets really interesting for you as a certified hacking forensic investigator. The internet, as we know, is a double-edged sword. On one hand, it's a tool for progress. On the other, it seems to amplify criminal activity. What kinds of criminal activities have specifically benefited from these digital advances, making them more prevalent or maybe harder to combat?
Indeed, the internet and digital networks are, unfortunately, quite fertile ground for criminal activity. They create new vulnerabilities and offer elements like anonymity, speed, and just vast scale that criminals exploit. Most existing crimes can be replicated online, and entirely new crimes exploiting specific digital features have emerged and, frankly, continue to emerge almost daily.
What are some concrete examples of these cybercrimes that the source outlines? The ones the CHFI is most likely to encounter day to day.
Well, the source lists several key types that really form the core of many cybercrime investigations. We have computer break-ins, often referred to legally as trespass. This is essentially illegal access to all or any part of a computer system without proper authorization. This is your classic hacking. Then there's illegal interception. This involves, without right and using technical means, secretly intercepting non-public transmissions of computer data. Think of someone sniffing network traffic to steal sensitive information like passwords or credit card numbers.
Like digitally eavesdropping on conversations and data flows, yeah.
Exactly. We also see data interference, which is the unauthorized damaging, deleting, deteriorating, altering, or suppressing of computer data. And closely related is system interference, where someone seriously hinders the functioning of a computer system by manipulating data, again, without authorization. These are really about disrupting operations or corrupting information, often through things like malware or denial of service attacks.
So disrupting operations or corrupting information are major categories. What else falls under this umbrella?
Other significant categories include the possession of obscenity and prohibited pornography, specifically things like child pornography and bestiality, which are never, ever protected forms of speech. Digital platforms, sadly, make the distribution and access of these materials easier, leading to profoundly sensitive and difficult forensic investigations. We also have industrial espionage, the theft of trade secrets or confidential intellectual property. Email fraud, which involves deceptive practices via email, like phishing scams or business email compromise, is huge. And harassment, encompassing malicious communication that can take many forms online, from cyberbullying to direct online threats.
And even things like defacing websites fall under this, right? Like cyber vandalism, as some people call it.
Yes. Web page defacements, or cyber vandalism, are unauthorized alterations of websites. It's a very visible and often reputationally damaging form of digital mischief. And of course, the theft of company documents, now often digital theft of proprietary information, is a constant threat that requires detailed forensic tracing to figure out who took what and when. This list really highlights how familiar criminal motivations have found new, incredibly powerful avenues in the digital realm.
That's a pretty comprehensive list. It really highlights how many traditional crimes simply found new avenues online, becoming faster and more widespread. But despite these being, as you said, age-old crimes with new tech, law enforcement still faces significant hurdles that make your job as a CHFI incredibly difficult sometimes. What are those primary challenges for investigators?
Well, despite the seemingly familiar nature of some of these crimes, law enforcement faces several critical difficulties in the digital realm. First, there are often increased investigative costs. This is due to the need for high-priced specialists like yourselves who understand the intricate technical aspects of cybercrime. This isn't your average street crime investigation. It requires specialized training and tools, which cost money.
Right, so you can't just send any officer. You need someone with deep technical expertise, and that's often a limited resource.
Exactly. Second, there are real difficulties with real-time investigations. Digital traces can be incredibly ephemeral, disappearing quickly, making it very hard to track activities in the moment, especially across live dynamic networks. Third, the ease of anonymity on the internet allows offenders to obscure their identity through things like proxies, virtual private networks, VPNs, anonymizing networks like Tor, and other techniques, which really complicates attribution figuring out who actually did it. Fourth, and this is critical, there are significant difficulties with jurisdictional issues. When data flows across borders, where does the crime actually take place? Which countries' laws apply? This whole borderless internet problem creates immense legal and logistical headaches.
That's a huge one, the borderless internet problem. We should definitely dive into that more. What other challenges are there?
Okay, fifth, the rapid technological evolution means laws often struggle to keep pace with new tools, new methods, and new vulnerabilities. Legislatures are frequently playing catch-up, writing laws for technologies that might already be outdated by the time the law passes. And finally, the irrelevance of geographic distance means a hacker can be sitting anywhere in the world, impacting victims anywhere else. This really complicates traditional notions of physical law enforcement presence and the need for international cooperation. These factors all combine to make cybercrime a uniquely challenging domain for law enforcement and, consequently, for your forensic work.
Jurisdiction is clearly a huge topic in digital forensics. You just mentioned it as a major challenge for law enforcement. What exactly does jurisdiction mean, and why is it so incredibly complicated in the digital realm, especially for a CHFI trying to figure out which rules apply?
Right? Jurisdiction, at its heart, asks the fundamental question, where should the case be heard? It's about the court's authority. For a court to even consider hearing a case, it needs to establish two types of jurisdiction. The first is subject matter jurisdiction. This is the court's power to hear a particular type of dispute. So criminal courts hear crimes, family courts handle divorces, civil courts deal with torts and contracts, and so on. It defines the kind of legal issue a specific court is competent to address. As a CHFI, you need to know if the court you might eventually present evidence to actually has the authority over the type of crime or civil wrong committed.
Okay, so a traffic court wouldn't hear a murder case. That makes sense. What's the second type, and how does the digital world mess with it?
The second type is personal jurisdiction. This refers to the court's power to enforce a judgment over a particular defendant, whether it's a person or a company. This defines how far a jurisdiction believes it can reasonably assert its authority over that defendant. It might be strictly local, for instance, only extending to residents within a specific city or state. Or, hypothetically, a jurisdiction might perceive its reach as encompassing the entire globe, which, as you can imagine, leads to significant conflicts when these perceived boundaries overlap or clash with another nation's claims. The Internet's borderless nature fundamentally challenges domestic law in almost every area, from simple e-commerce disputes right up to complex international cybercrime investigations, because it decouples actions from physical location.
So it's not just about where the person physically is, but maybe where the digital action happened or where the effect was felt, which could be literally anywhere. That sounds like it could get incredibly messy very quickly. Can you give us a vivid what-if scenario to truly illustrate this complexity, something that shows how tangled it can get?
It absolutely can get tangled. The source describes a kind of triple threat scenario that really illustrates this perfectly. Imagine this. A hacker sitting in jurisdiction A launches a sophisticated denial-of-service attack against a critical server that is physically located in jurisdiction B. However, that server is owned and controlled by a multinational company with its headquarters and most of its victim data located back in jurisdiction C. Now, where did the crime actually happen? Is it jurisdiction A where the hacker sat? Is it jurisdiction B where the server was impacted? Or is it jurisdiction C where the company is headquartered and the main harm occurred? Or maybe all three?
Wow, yeah. Which law applies? Who investigates? Who prosecutes?
Exactly. In such intricate cases, international law and treaty conventions become absolutely critical for coordinating how data is handled, how information is shared between agencies, and how offenders can ultimately be prosecuted across these multiple legal boundaries. Without effective international cooperation, such cases would quickly become unmanageable, leaving you, the CHFI, potentially unsure whose rules to follow, or worse, collecting evidence in a way that might be perfectly legal in one place, but inadmissible in another. This really highlights why understanding these international frameworks and cooperation mechanisms is so crucial for your work, especially if it involves cross-border elements.
Definitely. Okay, moving beyond direct attacks and system interference, digital spaces also seem to amplify issues like defamation and harassment. These can have devastating personal and professional consequences. How do these legal concepts, which traditionally applied in the physical world, translate and apply online? What should a CHFI know about investigating these kinds of harms?
That's a great question, as online interactions really do introduce unique challenges to these areas of law. Let's start with defamation and injurious falsehood. It's important to remember, even in countries with strong free speech protections, like the U.S. with its First Amendment, there isn't an overriding right to say absolutely anything without consequence. You can, without a doubt, defame someone using an electronic message, a blog post, a social media comment, you name it. For you, this often means identifying the source of potentially defamatory content becomes a key investigative task, proving who published it.
So free speech doesn't mean freedom from repercussions for harmful speech. What actually makes an online statement legally defamatory? What's the threshold?
Right. Generally speaking, a statement is considered defamatory if it's likely to result in a loss of reputation for the person it's about, as viewed by a reasonable person in the community. To establish defamation in court, three things are usually needed. First, there has to be a defamatory statement, material, or imputation. Second, that statement must identify the plaintiff, the person claiming defamation, even if it's indirectly. And third, the statement must be published to a third person, meaning at least one person beyond the plaintiff has to see or hear it. And here's a critical point for the digital age we live in. If even a single person views information that's been uploaded to the internet, that information is generally considered published in the legal sense. That's a very low bar, really underscoring the speed and potential reach of online communication.
Wow, so just one view online counts as publication. That's a massive shift from how traditional media worked, like needing a newspaper run or a broadcast.
It is a huge shift. Now, related to this, if an attack is made not against a person's reputation, but against an organization's offering, say, someone publishes a false statement about a company's product, claiming it's unsafe or fraudulent, it might be possible to establish what's called an injurious falsehood. This requires proving that the malicious publication caused actual financial damage to the organization. Digital forensics can be crucial here, helping trace the communications to potentially offer proof of that malicious intent behind the false claims.
What if your client is the one accused of defamation? Are there any common defenses they might raise?
Yes, there are several primary defenses against a defamation claim. A key one is proving the statement is true or substantially true. Truth is generally an absolute defense. In many jurisdictions, legal doctrines like absolute privilege protect statements made in certain contexts, like court proceedings or parliamentary debates. Qualified privilege often extends to things like accurate reporting of those proceedings by the media. Other potential defenses might include a duty to divulge certain information, like reporting suspected crimes to authorities, specific jurisdictional protections, such as whistleblower laws, participation in legitimate political debate, expressing fair comment, honest opinion based on true facts, or even if the plaintiff actually gave consent to the statement being published. For a CHFI involved in such a case, your role is often to find all relevant digital communications, emails, posts, logs, etc. that might support these defenses or, conversely, refute the claims being made.
And historically, we've had terms like slander for spoken defamation and libel for written. Do those still apply neatly in the digital age with things like videos or voice notes?
That's a good point. Traditionally, yes, verbal defamation was called slander, while published material was libel. In the digital realm, most online defamation would likely fall under libel due to its published, often written, potentially permanent or semi-permanent nature. Even a video or audio file online is considered published. For you, the forensic practitioner, involvement primarily comes in civil defamation cases, where the goal is often determining the source of anonymous emails or forum posts or maybe malicious web comments. Even if anonymous accounts or pseudonyms are used, digital traces often remain on an offender's computer or phone or in server logs, which can be forensically recovered. This helps to unmask the digital defamer.
So forensics is absolutely key to identifying who is behind these reputation attacks. What about harassment and cyberstalking? These feel particularly amplified online and can have immediate, terrifying impacts on victims.
They absolutely are amplified, and they're a serious concern. Harassment, whether it's racial, sexual, stalking, or general bullying, is generally prohibited by legislation and is taken very seriously. In the workplace context, employers have a legal obligation not to tolerate unwelcome, unsolicited, or unreciprocated behavior that a reasonable person would consider offensive, humiliating, or intimidating. This includes behavior of a sexual nature, of course, but also targeting a person's characteristics like their race, age, gender, or disability. It encompasses everything from sending obscene communications or derogatory remarks to even posting visually ridiculing images online. As a CHFI, you might be tasked with investigating internal communications, emails, social media activity, or company device usage to document such behavior for HR or legal action.
What are the key points for a forensic professional to remember when they're involved in harassment investigations? Things that might be different from other cases.
Okay, 3 crucial points stand out from the source material regarding workplace harassment. First, a single incident can be enough to constitute harassment. You don't necessarily need a repeated pattern of behavior. Second, the harasser's intentions are generally irrelevant. What matters is the impact on the victim and whether a reasonable person in their position would find the behavior offensive or intimidating. I was just joking. Is often not a valid defense. Third, and this is very important for organizations, an employer can potentially be held liable if an employee commits harassment and the employer cannot prove it took reasonable steps to prevent it from happening in the first place, like having clear policies and training. This makes your digital forensic investigations into internal harassment complaints incredibly important for managing organizational liability and, more importantly, protecting employees.
And sexual harassment is a common form you mentioned.
Yes. Sadly, it's the most common form that appears before courts and tribunals. It's important to note it's not limited by gender, nor does it only occur between opposite sexes. It encompasses a wide range of behaviors, including the unwanted publication or distribution of sexual images or statements. And then we have cyberstalking. This is essentially the distribution of malicious communication through email and the internet, specifically designed to harass, intimidate, or instill fear in the victim. While it uses new technology, its underlying principles are essentially the same as other forms of malicious communication or stalking, and it's generally handled by the usual civil and criminal law methods. For instance, the UK has the Malicious Communications Act. Your ability as a CHFI to trace these digital footprints, emails, messages, social media interactions is absolutely vital for identifying perpetrators and providing evidence to help stop the stalking.
Okay, finally in this section, let's address pornography and obscenity online. This area seems particularly contentious and frankly very sensitive. How do legal systems define and protect, or perhaps not protect, certain types of content in the digital realm?
This is indeed a complex and highly sensitive area with some critical legal distinctions. In the U.S., for instance, pornography involving adults is generally protected as a form of speech under the First Amendment of the Constitution. However, obscenity is not constitutionally protected speech. While obscenity might be legally possessed by an individual in the privacy of their own home, its distribution, particularly commercial distribution, is generally illegal. The Miller test, which was articulated by the U.S. Supreme Court in the 1973 case of Miller v. California, is the standard used in the U.S. to determine whether specific expression has crossed that line from protected, albeit potentially offensive, pornography into unprotected obscenity.
Can you walk us through the Miller test? This sounds like a key legal concept for anyone dealing with potentially explicit digital material.
Sure. The Miller test has three distinct parts, or prongs, and all three must be met for something to be deemed legally obscene under U.S. law. First, would the average person, applying contemporary community standards, find that the work, taken as a whole, appeals predominantly to the prurient interest, meaning a shameful or morbid interest in nudity, sex, or excretion? Second, does the work depict or describe, in a patently offensive way, sexual conduct that is specifically defined by the applicable state law? And third, does the work, taken as a whole, lack serious literary, artistic, political, or scientific value, often called the LAPS test? These are very specific criteria, but as you can imagine, terms like contemporary community standards and patently offensive can be open to significant interpretation, especially online where community is hard to define.
That is a very specific set of criteria, and I can definitely see how community standards could vary wildly online, making it really difficult to apply consistently. Did Congress try to regulate this more broadly in the early days of the internet?
Yes, they did. The U.S. Congress tried to address the problem of minors' easy access to inappropriate online material through the Telecommunications Act of 1996. Specifically, Title V of that act was known as the Communications Decency Act, or CDA. However, key sections of the CDA, specifically sections 223A and D, which tried to criminalize the transmission of indecent or patently offensive material to minors, were struck down by the Supreme Court in the landmark case Reno v. American Civil Liberties Union in 1997. The court found those provisions overly broad and vague, violating the First Amendment. As a result of this and subsequent legal challenges, there's still no clear, universally applicable community standard that defines obscenity for the entire internet within the U.S. This means what's considered legally obscene in one state or community might not be in another, which certainly complicates investigations that cross state or even national lines.
So it's still largely a state-by-state or maybe even community-by-community standard and practice for obscenity. But there's one critical exception you mentioned earlier, right? Something that is universally condemned and illegal.
Absolutely, and this is the most critical distinction in this entire area. Child pornography. Child pornography is never protected as free speech under any circumstances and is always illegal, universally. Its creation, possession, distribution, and viewing are serious crimes worldwide. The internet has tragically facilitated both access to existing child sexual abuse material, CISSP, and horrifyingly, the solicitation of children by pedophiles. This makes digital forensics in these cases an incredibly important, though often emotionally taxing, area of investigation. For CHFI, your work in identifying, preserving, meticulously documenting, and reporting this material is absolutely vital to protect children and bring perpetrators to justice. There is zero ambiguity here.
Understood. A very clear and vital line. Now, let's shift gears slightly to privacy. Privacy is such a huge concern today, especially with so much of our lives moving online. How do legal systems define and protect our right to be left alone, as it's sometimes called, in this increasingly interconnected digital world? For a CHFI, this often means balancing the need for investigation with respecting individual rights.
Privacy is a concept that has definitely evolved significantly, especially with technology. Justice Cooley famously defined it way back as the right to be left alone. Others, though, particularly in the digital context, view privacy more as the right to be anonymous or the right to control one's personal information. These different definitions naturally imply different legal implications and protections. Legally, privacy generally operates like a two-sided coin. It protects individuals from unwarranted government intrusion and also from intrusions by private individuals or corporations. The core idea really is the protection of our private lives, allowing us control over our personal information, our solitude, and our interactions.
And this right isn't explicitly mentioned in the U.S. Constitution, correct? It's often derived or interpreted, which leads to debate.
That's absolutely right. The word privacy itself appears nowhere in the U.S. Constitution. As a result, the right to privacy in the U.S. has developed largely as a separate body of law, often interpreted from other rights. The Fourth Amendment, which prohibits unreasonable searches and seizures, has been a major foundation for many of these privacy rights, particularly concerning government actions and surveillance. In contrast, in Europe, the right to privacy has been more explicitly integrated into European treaty conventions and statutory law, like the well-known General Data Protection Regulation, GDPR, which grants individuals significant control over their personal data.
What are some of the key legal pillars for privacy that have emerged from common law, particularly tort law, that are relevant for us thinking about digital interactions?
Okay, from common law, particularly tort law traditions, four main pillars or types of privacy invasion have been recognized. First, the right to stop another from appropriating your name or likeness, usually for commercial gain, without your permission. Think unauthorized use of your photo in an ad. Second, freedom from unreasonable intrusion upon your seclusion or solitude. This involves intentional interference with your private affairs. Third, freedom from publicity that places you in a false light in the public eye, presenting you in a way that damages your reputation. This is closely linked to defamation, but focuses more on the false impression created. And fourth, freedom from the public disclosure of private facts, revealing embarrassing private information about someone that is not of legitimate public concern. As a CHFI, you're constantly navigating these boundaries, ensuring your investigative techniques don't inadvertently cross these lines and violate someone's reasonable expectation of privacy.
Beyond common law torts, are there specific statutes in the U.S. that protect privacy in the digital age that a CHFI should definitely be aware of? You mentioned GDPR in Europe. What about the U.S.?
Yes. While the U.S. doesn't have a single overarching federal privacy law like GDPR, there are several key U.S. privacy statutes enacted over the years that create a kind of sector-specific patchwork of protections. For example, the Electronic Communications Privacy Act, ECPA of 2000, was specifically designed to regulate the interception of electronic communications like email and wiretaps. The Privacy Act of 1974 limits the amount of personal information that federal government agencies can collect about individuals and how they can use it. The Fair Credit Reporting Act, FCRA, as amended over time, regulates the collection, dissemination, and use of consumer information by credit reporting agencies. And the Federal Right to Financial Privacy Act, 1978, limits how much customer financial data banks and other financial institutions can disclose to the U.S. federal government.
Okay, so a lot of industry-specific protections there, creating sort of a digital shield for various types of sensitive data.
Exactly. And there are more, covering different areas. For instance, the Video Privacy Protection Act of 1988, sometimes called the Bork Bill, prohibits movie rental companies and now streaming services from disclosing customer rental or viewing data without consent. The Cable Communications Policy Act of 1984 prevents cable companies from collecting certain subscriber data without consent. The Equal Credit Opportunity Act, ETOA, prohibits creditors from collecting data like gender, race, or religion from loan applicants. And the Family Educational Rights and Privacy Act, FERPA, of 1974, gives students certain rights regarding their educational records, including the right to inspect and review them and challenge inaccuracies. These statutes collectively form a complex web of privacy protections in the U.S., and as a CHFI, you need to be generally aware of how they might impact the data you encounter and collect during an investigation, ensuring you have the legal right to access it.
That's definitely a lot of legislation covering different aspects of our digital and personal lives. Now, let's connect this directly to searches and the Fourth Amendment you mentioned. When law enforcement needs to access digital evidence, what's the general rule for a CHFI to follow to ensure their work is legally sound and the evidence admissible?
Okay, the general rule, especially in much of the common law world, think USA, UK, Canada, New Zealand, Australia, is that law enforcement generally needs to obtain a search warrant from a judge or magistrate to legally search for and seize evidence. This warrant isn't just a blank check, though. It must typically state the grounds for the application, the probable cause, the specific law that has allegedly been broken, and critically, in places like the US and UK, it must specifically describe the premises to be searched and the particular items or types of information being sought. This specificity requirement is crucial to protect against overly broad, intrusive phishing expeditions by the government. And for you, it means knowing the exact scope of your authorization before you begin any examination.
So it's definitely not a blanket permission to look for anything and everything. The warrant has to be very targeted, ensuring investigators don't just go rummaging through someone's entire digital life without justification.
Precisely. In the U.S., you have two key layers here. The Fourth Amendment prohibits unreasonable searches and seizures conducted by the government. And then you have statutes like the Electronic Communications Privacy Act, ECPA, which applies to everyone, government or private individuals, companies, and prohibits the unlawful interception or access to stored electronic communications without proper authorization. So you have a constitutional protection against government overreach and specific statutory protections against both government and private interference, which together define the core legal boundaries for your investigations involving communications and stored data.
But here's where it gets really tricky with digital evidence, isn't it? Something often called the digital loophole. In the physical world, a search has practical time limits. You can only be physically present in a house searching for so long. But with digital evidence, it seems like that rule gets bent quite a bit. How does that impact a CHFI's work and the scope of a search?
This is a significant challenge, and it's something you need to be acutely aware of as a practitioner. Unlike physical searches, which have inherent time and space limits, digital evidence can be perfectly copied. For example, an investigator can make a bit-for-bit forensic image of a hard drive or a mobile device. They take this copy back to the lab. They are then often able to continue to search these digital files, essentially at their leisure, potentially even for keywords, file types, or information strings that might be beyond the scope of what was originally authorized in the warrant. And there's often no effective time limit imposed on this subsequent analysis. Current U.S. federal law, for instance, provides relatively little specific guidance on this beyond requiring the return of seized property if the seizure was illegal or if the evidence is no longer needed for the case. It doesn't always clearly address the indefinite retention and searching of copies.
That's a huge difference. So an investigator could potentially stumble upon evidence of a completely different crime while sifting through a forensic copy of data maybe months later, and there's no clear legal limit on that continued searching in some cases. This seems to really push the boundaries of the Fourth Amendment's people, not places protection idea.
Exactly. The Fourth Amendment's traditional rule is that an investigator can look in any place listed on the warrant where the specified evidence might conceivably be concealed. But traditionally, they couldn't just keep looking indefinitely or expand the search beyond the evidence they sought for the initial crime. With electronic evidence, however, relevant data might be stored almost anywhere on a device fragmented, hidden, encrypted. This means an investigator might argue they need to electronically look anywhere within that digital copy to ensure they find all relevant evidence for the warranted offense. The landmark case Katz v. United States back in 1967 famously stated, "The Fourth Amendment protects people, not places," emphasizing privacy expectations. Yet its practical application often remains deeply tied to physical locations and containers. This creates this unique dilemma in the digital realm where data is everywhere and nowhere simultaneously. As a CHFI, you must understand the legal limits defined by your warrant and the relevant case law in your jurisdiction, and avoid going on an unauthorized digital fishing expedition, even if tempting evidence for another matter pops up. Documenting your search methodology is key here.
Okay, so warrants are generally required, but you mentioned exceptions. What are the main exceptions to the warrant rule that you, as a CHFI, might encounter in the field, where you might legally seize or examine evidence without one?
Right, there are a few well-established exceptions where law enforcement wouldn't necessarily need a warrant, although they are often narrowly interpreted by courts. Evidence can potentially be seized when it's in plain view. This means it's immediately apparent as contraband or evidence of a crime, and is discovered inadvertently by an officer who is lawfully in a position to see it, like say a clearly visible illegal weapon on a car seat during a traffic stop, or perhaps child pornography images clearly displayed on an unlocked computer screen during a lawful entry. Another major exception is where valid consent to search has been granted by the owner of the property or someone else with the proper legal authority to give that consent. However, consent must be voluntary and can generally be revoked at any time. And finally, situations involving exigency or urgent circumstances. This could be an emergency that threatens life or safety, may cause serious bodily harm, or presents an imminent risk of the destruction or removal of critical evidence. These might allow for a warrantless search or seizure to prevent the immediate harm or loss of evidence. However, relying on these exceptions can be legally risky, so the standard procedure is always to get a warrant whenever feasible.
And for an investigator to even get that search warrant in the first place, they have to convince the court, usually a judge or magistrate, of 3 key things, right? These are probably fundamental for any CHFI submitting an affidavit to support a warrant application.
Yes, absolutely fundamental. To secure a warrant, you, as the investigator, typically need to establish and articulate 3 points to the court, demonstrating probable cause. First, that a criminal act has likely been committed. You need to show more than just a hunch. Second, that evidence relating to that crime likely exists and is available to be found. And third, that it is probable the evidence will be found at the specific place being searched or on the specific device or account. These criteria ensure that warrants are not issued lightly or on mere suspicion, but are based on a reasonable belief, probable cause, ensuring there are solid legal and ethical grounds for your investigation before any search begins.
Okay, shifting from criminal searches to civil ones, what about civil search orders? The source material mentions Anton Pillar orders. What exactly are those, and why are they relevant for a CHFI? They sound quite dramatic.
They can be quite dramatic. An Anton Pillar order is a type of civil court order originating in the UK that provides the applicant, the plaintiff, with the right to search the respondent's defendant's premises and seize relevant evidence without any prior warning. These are quite powerful and are considered draconian because of the surprise element. In the U.S., for example, organizations like the Business Software Alliance have sometimes used similar legal mechanisms, often based on copyright or trademark law, as a remedy to stop illegal software use, what's often termed software piracy, or other forms of intellectual property infringement. The goal is usually to preserve evidence and recover infringing property before the defendant has a chance to destroy it. For a CHFI involved in executing such an order, it means you might be conducting a search with virtually no warning to the other side, often under immense pressure and tight timelines. Your absolute priority in such a high-stakes, rapid response situation must be the careful preservation of all potential evidence, maintaining an impeccable chain of custody and meticulous documentation of everything you do and find, just as you would in any criminal case. Precision is key.
So it's essentially a way for a private party in a civil lawsuit to get immediate surprise access to someone else's property to prevent the destruction of crucial evidence. That sounds like it would need a very high justification. What's the legal test for granting such an order since it's so powerful?
Exactly. It's not granted lightly. In the original 1976 UK case, Anton Pillar KGV manufacturing process is limited, Lord Justice Ormrod laid out a strict 3-step test for granting this type of extraordinary order. First, there must be an extremely strong prima facie case against the respondent. This means, based on the initial evidence presented, it appears very likely that the applicant will ultimately win the lawsuit. It has to be more than just arguable. Second, the damage, whether potential or actual, must be very serious for the applicant. The harm they stand to suffer if the evidence is destroyed must be significant. And third, there must be clear evidence that the respondents have in their possession incriminating documents or items. And D, there must be a real possibility that they may destroy such material if they were given any warning before a normal court hearing, inter partes hearing. This fear of destruction is key.
That definitely sounds like a high bar to clear, but understandable given the power it grants. Are these specific Anton Pillar orders still widely used in places like the UK today?
Well, in the UK specifically, the classic Anton Pillar orders have, for the most part, been somewhat outmoded or replaced by the introduction of a statutory search order under the Civil Procedure Act of 1997, which provides similar powers but within a more defined statutory framework. However, applications seeking similar types of ex parte, without notice search and preservation orders, are still common in many other common law jurisdictions, such as Canada, Australia, and even sometimes in specific contexts in the US and places like France, which have analogous procedures. The underlying principle of preventing evidence destruction in civil cases remains relevant globally. So depending on where your investigation takes you, you might still encounter procedures derived from or similar to the Anton pillar concept.
Got it. So, knowing who has permission to do what with digital assets is clearly crucial in many of these scenarios. How do legal systems define authorization in the digital realm, and what does this concept mean practically for a CHFI?
In legal terms, authorization is pretty straightforwardly defined as the legal right to use a product, a service, or access data, usually within agreed-upon terms. This permission can be either implied or explicit. An example of implied authorization would be when you browse a public website for its intended purpose. You don't typically need a specific signed document saying you're allowed to look at the homepage. The context implies permission. Explicit authorization, on the other hand, occurs when you use, say, your online banking service after having authenticated using your valid username and password. You've been explicitly granted permission to access your specific account through that defined process. For a CHFI, proving or disproving authorization is often absolutely central to many cybercrime cases, as unauthorized access is a core element of numerous offenses, from hacking to data theft. Determining the scope of any authorization given is key.
So, implied is when it's generally understood or expected, and explicit is when you've been given clear, direct permission, like through credentials or contract. And this concept of authorization ties directly into licensing, doesn't it? Especially with software or digital content.
It absolutely does. In legal terms, the act of granting permissions through authorization is, in effect, the granting of a license. To license something or grant a license is simply to give permission or authorization to do something. The license itself is the formal demonstration or evidence of that permission. In the case of software, for instance, the End-User License Agreement, EULA, grants you the right to use the software as long as you agree to abide by its specific terms and conditions. A simple way to think about it, especially in intellectual property law, is that a license is essentially a promise by the licensor, the owner, not to sue the licensee, the user, for infringement, provided the licensee stays within the bounds of the license. Your forensic work can often help determine if software found on the system was legally licensed or if it's pirated, which can have significant financial and legal implications for individuals or companies.
And that leads us directly into the broader topic of intellectual property, IP, which is all about protecting creative works and innovations. What sorts of things fall under intellectual property in the digital context, and why should a CHFI care about IP law?
Intellectual property laws are designed to protect people's intellectual designs, creations, and works. It's absolutely crucial to understand that when you're surfing the internet, almost everything you see, the text on a web page, the images, the videos, the software code running behind the scenes, is typically protected by copyright law automatically upon creation. Additionally, the actual website name, domain name, logos, and branding used are often the subject of trademark law or legal actions related to passing off, which prevents unfairly benefiting from another's reputation. As a CHFI, you might find yourself investigating the theft of valuable source code, proprietary algorithms, copyrighted digital media like movies or music, counterfeit goods sold online, or perhaps trademark infringement being used in phishing scams to impersonate legitimate companies. Understanding IP rights helps you identify what's been stolen or misused.
So it's not just big corporations protecting major patents, it's practically everything created online, from a blog post to a complex piece of software.
Exactly. The law of intellectual property is aimed at safeguarding people's intangible ideas and creativity, provided they exist in some tangible form, even that form is digital. It's a really expansive area of law. It deals with the protection of intangible items such as ideas and creativity that manifest as, say, a movie, a piece of music, a brand name, a unique design, or software code. Many separate subject areas exist within the umbrella of intellectual property law. The main ones include copyright, protecting creative works, patents, protecting inventions, trademarks, protecting brands, and trade secrets, protecting confidential business information. Others include design rights, rules around domain names, moral rights, like the right of an author to be identified, performance rights, and the concept of passing off. Understanding these basic categories helps you, as an investigator, identify what kind of intellectual property might have been compromised or infringed upon during an incident.
That's definitely a huge range, covering almost every kind of digital creation or brand identity. Now, all this protection is great, but it means nothing if you can't prove an infringement or theft in court. So let's talk about evidence law specifically in the digital realm. What are the key considerations for electronic evidence, and what are the major pitfalls that a CHFI absolutely must avoid to ensure their findings are usable?
Okay, electronic evidence in law really refers to the legal recognition and the evidential value, or weight, given to evidence that exists in digital format when it's presented during litigation, either civil or criminal. Foundational legal acts are really important here. Things like the U.S. Federal Rules of Evidence, the U.K.'s Police and Criminal Evidence Act, PACE-AV, and the U.K. Civil Evidence Act. Similar rules and principles apply in most other developed jurisdictions. Before admitting any evidence, digital or otherwise, a court will generally ensure it meets several criteria. It must be relevant to the case, meaning it tends to prove or disprove a fact at issue. It must authentically fulfill what it's claimed to provide, meaning it is what it purports to be. The court also needs to determine whether the evidence constitutes hearsay, an out-of-court statement offered for its truth, and if it falls under a recognized exception to the hearsay rule, and generally assess its overall admissibility based on rules about prejudice or reliability. Your job, fundamentally, is to collect, preserve, and analyze digital evidence in a way that ensures it ticks all these boxes and survives legal scrutiny.
What are the primary issues that make digital evidence particularly challenging for a forensic investigator compared to, say, physical evidence like a document or a footprint?
Well, the primary issues concerning digital evidence often revolve around the incredible ease with which digital documents or data may be copied, altered, or even completely deleted without leaving obvious traces. This directly impacts its perceived reliability and value as evidence in court. Judges and juries might be skeptical if manipulation is easy. This ease of modification also has significant implications for civil liberties, as the nature of digital technologies has compounded the sheer amount of personal information available about us, making it technically far easier to violate privacy rights and other civil rights through unauthorized access or surveillance in this digital age. The sheer volume, volatility, it can change or disappear quickly, and complexity of digital data make it a very different beast to tame in a legal context compared to traditional physical evidence.
And you mentioned earlier that perhaps the most common and fatal mistake is collecting evidence without proper authorization. Why is it such a big deal for admissibility, and what's the CHFI's responsibility here?
It's absolutely critical. The most common mistake made in obtaining digital evidence, the one that can completely derail an otherwise solid case, occurs when it has been seized or accessed without proper legal authorization. Generally, as we discussed, a warrant issued by a court, or a specific court order, must be obtained before the collection of the evidence if it's to be admissible in court, especially in criminal cases. While exceptions exist plain view, consent, exigent circumstances relying on those can be legally precarious. Failing to follow proper authorization procedures can render otherwise compelling, smoking gun evidence completely useless, inadmissible in a legal proceeding. Your adherence to proper legal procedure, understanding the scope of your authority, whether from a warrant, consent, or company policy, is paramount. Without it, all your brilliant technical work might ultimately be for nothing.
Okay, point taken. Authorization first. Once you have the evidence legally, how do you ensure its reliability and authenticity so it can actually be presented effectively in court?
Right, so for evidence to be considered admissible and then given appropriate weight by the court, judge, or jury, it must typically go through a process known as authentication. This process is designed to determine whether the evidence truly is what its proponent, the party introducing it, claims it is. Is this email really from the defendant? Is this log file accurate and untampered with? Establishing authenticity, in turn, helps determine the evidence's probative weight, meaning how much it actually helps prove or disprove a relevant point in the case. It's worth noting that even if some reasonable doubt exists about the absolute reliability of a piece of electronic evidence, it may not automatically make it inadmissible entirely, but it will certainly reduce the weight or importance the court gives it. As a CHFI, your meticulous documentation of the chain of custody, who handled the evidence, when and why, and your detailed notes on the analysis procedures you followed are absolutely vital for authentication. This proves your evidence hasn't been contaminated or tampered with, and that your findings are reliable and repeatable.
We often hear about the best evidence rule in traditional law, which historically favored original documents over copies. How does that rule apply to digital copies, since almost everything in the digital world is technically a copy of data?
That's a great question, because the best evidence rule has had to adapt significantly for the digital age. The rule was originally introduced centuries ago, primarily to prevent a party from misrepresenting the contents of important writings like contracts or deeds by simply offering potentially inaccurate oral testimony about what the document said, instead of reducing the document itself. With digital evidence, however, an exact bit-for-bit duplicate or forensic copy can generally be made. The result is that courts almost universally recognize that a properly created forensic copy is generally acceptable as evidence, often considered legally equivalent to the original digital data for practical purposes. There is no single original file in the way there is an original paper contract. In fact, statutory provisions in some jurisdictions, like Australia's Electronic Transactions Act of 1999 we mentioned earlier, explicitly deem a digital copy or a reliable electronic reproduction equivalent to the original printed form for many legal purposes. Sometimes the digital format can even be preferable because it might contain hidden metadata or embedded materials, like track changes or macros in a Microsoft Word document, that wouldn't be visible in a simple printout but could be crucial evidence. So the law has largely adapted to the reality of digital data.
That's a practical adaptation indeed. What about the difference between direct and circumstantial evidence when we're talking about digital data? How do these apply to a CHFI's findings and how they're presented?
The distinction is important for understanding how evidence contributes to proving a case. Direct evidence is evidence that, if believed, categorically establishes a fact without needing any inference or presumption. For example, system authentication logs showing that a specific user account logged in at a specific time are generally accepted as direct evidence of that login event, short of credible proof that another party somehow used that specific account without authorization. It points directly to the fact of the login. Circumstantial evidence, on the other hand, is evidence that only suggests a fact or requires an inference to connect it to the conclusion you want the court to draw. Think of it like finding someone's fingerprints at a crime scene. It doesn't directly prove they committed the crime, but it strongly suggests they were there, requiring the jury to infer their involvement. Your job as a CHFI is often to provide as much direct evidence as possible, like logs, file timestamps, recovered deleted files, and then build a strong logical narrative using the circumstantial evidence like internet history patterns, communication fragments, tool artifacts to support your conclusions about what happened and who was responsible.
And what about scientific evidence standards? Digital forensics is definitely presented as a scientific discipline, so I imagine its findings and the methods used need to meet specific scientific standards to be accepted in court, especially if you're testifying as an expert.
Absolutely. The rules governing the admissibility of scientific evidence, particularly expert testimony based on scientific methods, apply squarely to digital forensics. In the United States, the landmark Supreme Court case Dober v. Merrill Dow Pharmaceuticals from 1993 set the standard for federal courts, and adopted by many states, for evaluating the reliability and admissibility of scientific expert testimony. Dober established a non-exhaustive four-part test or set of factors for judges to consider.
What are those 4 parts of the Dobert test? These sound absolutely crucial for any CHFI who might have to testify as an expert witness about their findings.
Okay, the Dober factors, which act as guidelines for the judge, the gatekeeper of evidence, generally ask. First, can the theory or technique be, and has it been tested? Is it falsifiable? Second, has the theory or technique been subjected to peer review and publication? This helps indicate scrutiny by the relevant scientific community. Third, what is the known or potential rate of error of the technique, and are there standards controlling the technique's operation? And fourth, is the theory or technique subject to general acceptance within the relevant scientific community? This incorporates the older Fry standard, but makes it just one factor among others. Now, for the most part, even though precise error rates haven't always been rigorously established for every single digital forensic tool or technique, electronic evidence derived from standard forensic practices has generally been accepted by courts as reliable scientific evidence. However, the most effective approach to continually validating methodologies and ensuring reliability remains peer review of your findings by another qualified investigator, preferably using multiple tools or techniques to independently verify the results. This demonstrates rigor and helps ensure your expert opinion will withstand scrutiny under Daubert or similar standards.
That sounds like the gold standard for ensuring the work holds up legally. Lastly, on evidence, you mentioned hearsay in the digital context. That's another legal term that can be confusing, especially when dealing with emails, text messages, or chat logs. How does the hearsay rule apply to digital evidence?
Right. Hearsay can be tricky. Think of hearsay fundamentally as secondhand information being offered in court to prove the truth of what that secondhand information says. For example, if a suspect wrote an email saying, "I committed the crime," bringing that email into court simply to prove that the suspect actually did commit the crime would generally be considered hearsay. The email is just repeating the suspect's out-of-court statement, "I committed the crime." To prove the crime itself, law enforcement would typically need other evidence, like a formal confession obtained legally, eyewitness testimony, or corroborating physical or digital evidence found through investigation, not just rely on the email repeating the claim. Hearsay is formally defined as a statement, other than one made by the declarant while testifying at the current trial or hearing, offered in evidence to prove the truth of the matter asserted in the statement. Now, there are many exceptions to the hearsay rule, like business records, statements against interest, excited utterances, and digital evidence like system logs might fall under some of these exceptions.
But the basic rule is you can't use an out-of-court statement to prove its own truth. As a CHFI, your primary job is to authenticate the digital artifact, prove the email was sent, the log was generated. It's then up to the lawyers to argue whether the content of that artifact is admissible under hearsay rules or fits an exception.
Okay, that clarifies the hearsay issue. So bringing all these legal principles together, jurisdiction, evidence rules, different types of laws, what does all this mean when crimes inevitably cross international borders? We need international collaboration to bring offenders to justice, right? It seems like this is where all these legal complexities truly converge and potentially clash.
Indeed, you've hit on a critical point. In a world where cybercrime is inherently borderless, effective international cooperation becomes absolutely essential. No single nation, no matter how powerful or technologically advanced, can realistically combat global cybercrime in isolation. One of the key players facilitating this cooperation is Interpol, specifically their Information Technology Crime ITC division.
What exactly is Interpol's role here? How do they act as a coordinating body for global cybercrime efforts? Are they like a world police force?
Not quite a world police force with arrest powers, no. Instead, the Interpol General Secretariat, based in Lyon, France, acts primarily as a regional and global coordinating body between the police forces of its member countries, currently 196 members. In the field of information technology crime, they coordinate numerous working parties and meetings, bringing together representatives from national computer crime units across Europe, Asia, North and South America, and Africa. Their activities include developing shared information security knowledge, researching crime prevention strategies, and publishing white papers and best practice guides for both law enforcement agencies and the general public. This research investigates both the current state of technology and its possible criminal implications, helping member nations stay ahead of emerging threats and, crucially, share vital intelligence and investigative leads across borders through secure channels.
So they're more about facilitating communication, sharing expertise, and coordinating efforts among national agencies, which is a very practical way to address the borderless problem. Beyond Interpol's coordination role, what about larger, more formalized international agreements or conventions designed to tackle cybercrime?
That brings us to perhaps the most significant international treaty in this area, the Council of Europe's Convention on Cybercrime. It's often referred to simply as the COE Convention or the Budapest Convention. This was opened for signature in Budapest back in 2001. It's marked as CET's No. 185, and it really was a landmark effort to harmonize and standardize national cybercrime laws and, critically, to improve international cooperation in investigating and prosecuting these offenses. It's not limited to European countries. Many nations outside Europe have also signed and ratified it, making it a truly global instrument. It was developed over several years by the Committee of Experts on Crime in Cyberspace, known as PCCY. This committee was tasked with a really comprehensive review of offenses committed via computer networks.
What kinds of issues did that committee look at? This sounds like a foundational effort to really define the problem internationally.
They looked at a whole range of issues, things like illegal money transactions conducted online, copyright violations in the digital sphere, and offenses against human dignity, particularly those committed through telecommunication networks like the internet. Think hate speech or child exploitation material. They also focused on finding common criminal law approaches, including agreed-upon definitions for key cybercrimes and appropriate sanctions. They considered the responsibilities of various actors like internet service providers, ISPs. Crucially, they explored the use of coercive investigative powers, including the very tricky possibility of transborder use of these powers. Things like remote interception of telecommunications, electronic surveillance across borders, search and seizure in information processing systems located abroad, and mechanisms for making illegal material inaccessible internationally. They also delved deep into those complex jurisdiction issues we discussed earlier, like determining the locus delicti, where the offense was legally committed, when multiple countries are involved, and how to avoid situations of double jeopardy, nebis idem, where someone might be prosecuted twice for the same crime in different countries.
That sounds incredibly ambitious, trying to get so many different countries with different legal systems on the same page. What was the ultimate aim of the COE Convention? What was it trying to achieve?
It was, and it continues to be, a very ambitious but necessary undertaking. The COE Convention primarily serves as a framework. Its main goals are, first, to harmonize the domestic criminal laws of the signatory nations in the area of cybercrime. Second, to provide for the necessary procedural powers for investigating and prosecuting these crimes effectively. And third, perhaps most importantly, to establish a fast and effective regime for international cooperation. It pushes member states towards harmonizing their definitions of key cybercrimes and their investigative procedures, making it easier for them to work together. It's structured into 4 main chapters. Chapter 1 covers the use of terms, definitions. Chapter 2 details measures to be taken at a domestic level, covering both substantive criminal law, defining offenses, and procedural law, investigative powers. Chapter 3 focuses on international cooperation, and Chapter 4 contains the final clauses.
And what kinds of specific offenses does the convention define for common adoption by signatory countries? What are the core cybercrimes it targets?
Okay, Chapter 2, which deals with the substantive law issues, the actual crimes, defines types of offenses grouped into 4 main categories. These include critical offenses against the confidentiality, integrity, and availability of computer data and systems. Specifically, illegal access, hacking, illegal interception, eavesdropping, data interference, damaging or deleting data, and system interference, disrupting systems like DOS attacks. It also covers computer-related offenses like misuse of devices, making or distributing hacking tools, computer-related forgery, and computer-related fraud. Then there are content-related offenses, most notably offenses related to child pornography. And finally, offenses related to infringements of copyright and neighboring rights. Importantly, the convention is also designed to apply to any traditional crime, like murder, terrorism, or financial fraud, that has been committed using a computer system, ensuring that existing criminal behaviors are covered even when new technologies facilitate them. Chapter 3 then lays out the essential international provisions, including detailed rules for mutual legal assistance, helping each other gather evidence, and extradition related to cybercrime. It also includes innovative provisions for things like trans-border access to stored computer data in certain circumstances that might not require formal mutual assistance requests, aiming to speed things up.
So it's really comprehensive, covering not just the definition of crimes, but also the practical tools and cooperation needed for nations to help each other investigate and prosecute them. That seems vital in a globalized digital world. What about other international groups? Did the G8 countries, the group of major industrialized nations, also develop their own plan for combating high-tech crime?
Yes, they did. The G8 countries. Action Plan to Combat High-Tech Crime represents another significant international effort running somewhat parallel to the COE Convention efforts. The G8 originated primarily as an economic summit. But back in 1996, a working group of IT crime experts within the G8 framework, known as the Lion Group, produced 40 recommendations specifically aimed at combating transnational organized crime more broadly. These were endorsed by the G8 heads of state. Following this, the G8 specifically formed a subgroup on high-tech crime to focus directly on the challenges posed by computers and networks.
What was the core mission of that G8 subgroup? What specific challenges were they trying to overcome that maybe differed from the Council of Europe's focus?
Their core mission, as stated, was to enhance the capability of the G8 member countries to prevent, investigate, and prosecute crimes involving computers, network communications, and other new technologies. Their focus was perhaps initially more operational and practical for law enforcement cooperation among the G8 nations. Their mission later explicitly expanded to include combating terrorist uses of the internet and protecting critical national information infrastructures, recognizing the growing link between cybercrime, terrorism, and national security in the post-9/11 era. They clearly understood the borderless nature of these crimes and the urgent need for a unified, pragmatic response among these major economies.
And what did this G8 subgroup achieve in terms of practical measures? Did they set up specific networks or publish guidelines?
Yes, they had several key concrete accomplishments aimed at improving day-to-day cooperation. They created a 247 network, allowing designated points of contact for high-tech crime within each member country to communicate quickly and efficiently. This network grew to include many non-G8 countries as well. They also established an international critical information infrastructure protection directory. They negotiated and agreed upon a set of widely accepted principles and a corresponding action plan specifically designed to combat high-tech crime, which influenced policy globally. They published various best practice documents, which were very practical things like security guides for computer networks aimed at prevention, guides on how to make effective international requests for legal assistance, MLTs, and methods for tracing network communications across borders. They also conducted threat and impact assessments for law enforcement regarding emerging challenges like new wireless technologies, the impact of encryption on investigations, and the proliferation of viruses, worms, and other malicious code. Furthermore, they conducted important training conferences for cybercrime agencies around the world and held forums designed to foster better cooperation between law enforcement and the private tech industry, recognizing that industry holds much of the data and expertise. These were very practical, actionable steps.
That sounds like a lot of practical, hands-on initiatives. What were the core principles, the specific points of the action plan they developed? These likely shaped global approaches significantly.
Okay, the G8 Statement of Principles included 10 key points that really set a tone for international expectations. These emphasize things like there must be no safe havens for those who abuse information technologies, that investigation and prosecution of international high-tech crimes must be coordinated effectively among all concerned states, that law enforcement personnel must be properly trained and equipped to address high-tech crimes. They also stated that legal systems must protect the confidentiality, integrity, and availability, the CIA triad, of data and systems, and ensure that serious abuse is penalized appropriately. And critically, that legal systems should permit the preservation of and quick access to electronic data needed for investigations.
And what did their principles say about the international exchange of evidence, which you mentioned is often a major hurdle?
Right. Their principles explicitly highlighted that mutual assistance regimes must ensure the timely gathering and exchange of evidence in international high-tech crime cases. Speed is often critical. Crucially, they also stated a principle that transborder electronic access by law enforcement to publicly available open-source information does not require authorization from the state where the data physically resides. This aimed to streamline intelligence gathering from public sources. They also committed to developing and employing common forensic standards for retrieving and authenticating electronic data, ensuring evidence would be reliable across borders. They encouraged designing information and telecommunication systems to help prevent and detect abuse and facilitate tracing offenders. And finally, they stressed the need for international coordination to avoid duplication of efforts and resources.
That sounds like a very proactive and highly collaborative approach laid out in those principles. What about the action plan itself? What were the specific directives or actions they committed to taking?
The action plan translated those principles into 10 specific directives for the G8 countries. These included establishing those 247 points of contact we mentioned, allocating sufficient trained personnel and resources to combat high-tech crime, reviewing national legal systems to ensure they appropriately criminalize abuses and remove impediments to investigation. They also committed to considering high-tech crimes specifically when negotiating mutual legal assistance treaties, MLTs, developing practical solutions for evidence preservation and facilitating lawful transborder searches, expediting procedures for obtaining and exchanging crucial traffic data internationally between carriers and law enforcement. Furthermore, the plan called for joint work with the tech industry to ensure new technologies consider law enforcement needs, often termed lawful access, ensuring urgent responses to mutual assistance requests from other countries, encouraging standards-making bodies to enhance security features, and importantly, developing and deploying compatible forensic standards across borders. It was really a comprehensive roadmap for practical international collaboration against cybercrime, setting a global precedent for how nations should ideally work together to address these transnational threats.
That is a huge international framework. Between the COE Convention and the G8 efforts, it really paints a picture of global consensus on the need to act. But how do these broad principles and convention articles actually translate into specific laws in different countries on the ground? It sounds like there's still likely to be a lot of variation, but probably some common ground too, which is exactly what a CHFI operating internationally needs to grasp.
You're absolutely right. While each country undoubtedly has its unique legal system, heavily influenced by its own history, culture, and legal traditions, like common law versus civil law systems, when it comes to the substance of cybercrime legislation, we see many common patterns emerging globally. Across the world, nations have been actively updating their penal codes or enacting specific cybercrime laws, often heavily influenced by frameworks like the Council of Europe Convention on Cybercrime and the G8 Action Plan principles. You see recurring themes everywhere: criminalizing unauthorized access, hacking, unauthorized data modification or deletion, interference with computer systems like DDoS attacks, the distribution of malware or hacking tools, computer-related fraud, and offenses related to child exploitation material online. It's truly a global effort to address shared digital threats driven by shared vulnerabilities.
And for you, understanding these common underlying principles and categories of offenses is often more important than memorizing every specific article number from dozens of different countries.
Okay, let's try to illustrate this with Australia, as our source provides a good detailed example of how one nation implements these principles in practice. What's their specific approach to cybercrime legislation look like?
Australia provides a really robust example of how a nation can develop a comprehensive legal framework that clearly reflects these international influences. Federally, they have several key pieces of legislation. The Electronic Transactions Act, 1999, deals with things like e-security, digital signatures, and the legal validity of electronic transactions. The Privacy Amendment, Private Sector Act, 2000 extended privacy principles to cover private organizations. But most significantly for cybercrime itself, they enacted the Cybercrime Act 2001. This act does two main things. It directly penalizes various forms of cybercrime within the Australian Criminal Code, and crucially, it implements many of the substantive law provisions found in Articles 2 through 6 of the Council of Europe Convention, covering illegal access, interception, data system interference, misuse of devices. It also implements the search and seizure provisions related to computer data found in Article 19 of the Convention.
So, they've clearly and deliberately adopted international standards into their domestic law. What types of specific new offenses did their Cybercrime Act introduce that a CHFI operating in or dealing with Australia might encounter?
The Cybercrime Act 2001 introduced a new division, Division 477 and 478, into Australia's Federal Criminal Code, specifically targeting computer offenses. Broadly, it covers serious computer offenses under Division 477. These involve unauthorized access, modification or impairment of data or electronic communication with the intent to commit a serious offense, like terrorism, fraud, etc., carrying a penalty of 5+ years. It also covers intentionally causing unauthorized impairment to data or electronic communication, even without further criminal intent. Other computer offenses under Division 478. These criminalize things like unauthorized access to or modification of what they term restricted data. This is a critical definition for you as an investigator. Restricted data simply means data held in any computer that has an access control system protecting it, like a password or encryption. The data itself doesn't have to be sensitive, just accessing it without permission is the offense. Simply viewing unauthorized restricted data can breach Section 478.1. Division 478 also covers unauthorized impairment of data held on a disk, like wiping a drive, and offenses related to tools and intent. This includes possessing or controlling data with the intent to commit a computer offense, or producing, supplying, or obtaining data, like hacking tools or stolen passwords, with that same criminal intent. This targets the preparation and facilitation phases of cybercrime. And a critical condition for conviction under many of these Australian offenses is that the access, modification, or impairment must be undertaken without authorization. This again highlights why proving or disproving the scope and existence of authorization is so often central to your forensic work in these cases.
And what specific powers does this Australian Act grant to law enforcement when they are dealing with digital evidence during an investigation, recognizing its unique nature?
The Act grants several key powers designed to help law enforcement effectively deal with digital evidence, acknowledging it's different from physical evidence. For instance, under warrant, law enforcement can take a thing, like a computer or phone, away from the premises to a different place for assessment or processing, specifically to determine if it contains seizable evidence. This allows for complex forensic analysis back at a lab. They also have the power, under warrant, to operate electronic equipment found at the warrant premises, specifically to access data relevant to the warrant, even if that data isn't physically stored at the premises. For example, accessing cloud-stored data through a logged-in device found on site. Furthermore, they can legally compel a person present at the search location to provide information or assistance necessary to copy data from equipment that might hold evidential material. They can even necessitate a person with specific knowledge of the computer system or security measures, like an IT admin, to assist them in accessing the data. These powers are designed to ensure that digital evidence, even if remote or protected, can be legally obtained and processed under judicial oversight.
Beyond the main Cybercrime Act, are there other important laws in Australia related to technology or privacy that are relevant for digital forensics practitioners?
Absolutely. Australia has a fairly comprehensive suite. The Telecommunications, Interception and Access Act 1979, as amended, governs access to telecommunications data and content. The Telecommunications Act 1997 itself contains provisions, including some amended to prevent fraud in connection with telecommunication systems. We already mentioned the Privacy Act 1988 and its significant privacy amendment Private Sector Act 2000. Together,
These establish the Australian Privacy Principles, APPs, that govern how both government agencies and private sector organizations handle personal information. Understanding these is crucial when dealing with sensitive data. And the Electronic Transactions Act, 1999, ETA, is also quite significant. It essentially allows businesses and individuals to fulfill many traditional legal requirements, like providing information in writing, giving a signature, producing a document, using electronic means. The ETA is explicitly based on two key principles. Functional equivalence, meaning paper-based and electronic transactions should be treated equally by the law where they achieve the same function, and technology neutrality, meaning the law should not discriminate between different forms of technology used to achieve that function. This demonstrates a clear legislative move towards recognizing digital interactions as legally equivalent to physical ones for many purposes. It's also worth noting that most Australian states and territories have also implemented their own computer-related offenses into their state criminal codes, often mirroring the federal offenses based on the Australian Model Criminal Code, creating some complexity between federal and state jurisdictions.
That's a very detailed and helpful look at Australia as a case study. So we see the clear influence of international conventions, specific cybercrime statutes, enhanced police powers, and related privacy and electronic transaction laws all working together. How do other nations, maybe from different legal traditions or regions, approach these same challenges? Can you give us a sense of the broader global landscape without getting bogged down in every single article number from every country? What are the common threads?
Certainly. What we find when we look globally are definite commonalities in the types of acts being criminalized and the overall spirit or intent of the laws, even if the specific legal language, penalties, or procedural details vary significantly based on national legal traditions. Many European nations, for instance, being heavily influenced by the Council of Europe Convention, have legislation that closely mirrors its structure. They typically criminalize unauthorized access, data interference, system interference, computer-related fraud and forgery, misuse of devices, and child pornography offenses online. Countries like France, Germany, the Netherlands, Italy, Spain, and the United Kingdom have all either amended their existing penal codes or enacted specific computer misuse acts to cover these core categories. They often focus on the intent required. Was it just unauthorized access, or was there intent to cause damage, commit fraud, or obtain specific data? The UK's Computer Misuse Act of 1990, as amended significantly in 2006 and later, is a classic example, clearly defining offenses like basic unauthorized access, access with intent to commit further offenses, and acts intending to impair computer operation, like distributing malware. Looking elsewhere, we see similar themes playing out. Canada's criminal code includes specific sections targeting things like obtaining computer service fraudulently, intercepting computer system functions without authorization, using a computer system to commit other offenses, and specific offenses related to mischief involving data, destroying, altering, obstructing use, denying access. India's Information Technology Act of 2000, though amended since, was a major step, addressing hacking with intent to cause wrongful loss or damage and defining penalties for damaging computer systems or data. The United States, with its complex dual federal and state system, has a vast body of relevant legislation. Federally, you have acts like the Computer Fraud and Abuse Act, CFAA, found in 18 U.S.C. 1030, the Wiretap Act, the Stored Communications Act, SCA, the Can-Spam Act, the Digital Millennium Copyright Act, NDMCA, and various others like the PROTECT Act, targeting child exploitation. On top of that, every single U.S. state also has its own codified legislation targeting various forms of computer crime, sometimes overlapping with or extending federal laws. The key takeaway for you, as a CHFI who might work on cases with international dimensions, is that almost every developed nation, and many developing nations, has recognized the need for and moved to specifically criminalize these core cyber offenses: unauthorized access, data manipulation, system disruption, online fraud, distribution of malicious tools, and child exploitation. They all grapple with the same fundamental challenges: establishing jurisdiction, ensuring digital evidence is admissible, keeping laws updated with technology, and fostering international cooperation. While the precise penalties or specific legal nuances will absolutely differ, and you must be aware of the specific laws in the jurisdiction you are operating, and the foundational principles that guide your forensic investigations, like proving authorization, or lack thereof, establishing intent where required, and maintaining meticulous defensible evidence handling procedures, remain universally critical. Your ability to operate ethically and effectively within these diverse but thematically similar legal frameworks is what makes your CHFI skill set so valuable globally.
Wow, okay. We have covered an absolutely incredible amount of ground in this deep dive into worldwide forensics acts and laws. This is dense but crucial stuff. So for our listener, thinking about everything we've discussed, what are the absolute critical takeaways, the main points they should really lock in from today's discussion to carry forward into their work or potential work as a CHFI?
Absolutely. Let's try to consolidate everything we've explored into some core actionable insights for you, the listener. First, always remember the inherent complexity and interconnectedness of electronic law. Please don't think of it as a standalone field. It's really a vast web that intersects with and challenges traditional criminal law, civil law, intellectual property, privacy law, and more. As a CHFI, you're navigating this constantly evolving landscape, so understanding its fluidity and breadth is your foundational first step. Second, really internalize that cybercrimes are often old crimes on new battlefields. While the tools are digital, the underlying criminal intent, things like theft, fraud, espionage, harassment, is often quite traditional. But, and this is key, the scale, the speed, and the potential anonymity that digital environments offer create truly unique challenges for investigation and prosecution, making your specialized forensic skills indispensable for attribution, reconstruction, and evidence presentation. Third, always be clear the fundamental legal distinctions, especially between civil and criminal law. This isn't just academic theory. It dictates everything from the required burden of proof, beyond a reasonable doubt versus preponderance of evidence, to the potential outcomes, punishment versus remedy, and the specific admissibility requirements for your evidence. You need to understand the context your findings will be used in, but always maintain the absolute highest standards of evidence handling regardless. Fourth, recognize jurisdiction's central and often incredibly complicated role. In our borderless digital world, determining where a case should be heard and whose laws apply is paramount and frequently involves intricate analysis, especially when data, perpetrators, and victims cross multiple national boundaries. That triple threat scenario we discussed really highlights why international cooperation and a solid awareness of cross-border legal frameworks are not just theoretical concepts, but essential for the admissibility and ultimate impact of your forensic findings. Fifth, be acutely aware of the various laws designed to protect reputation and personal safety online. This includes areas like defamation, harassment, cyberstalking, and the particularly sensitive area of obscenity. Always remembering the critical, non-negotiable distinction that child pornography and exploitation material are never protected and are universally illegal. Your investigations in these areas can directly contribute to protecting individuals and organizations from serious harm. Sixth, prioritize privacy considerations and adherence to proper legal procedure above almost everything else in your process. The right to privacy, whether explicit or derived, is a cornerstone of most legal systems, reinforced by various statutes and constitutional principles like the Fourth Amendment's protection against unreasonable searches. Always ensure you have proper legal authorization, typically via warrants, court orders, clear consent, or established policy for any evidence collection or system examination. Ignoring this can fatally undermine your entire investigation, no matter how technically brilliant your findings are. Seventh, appreciate the significant legal safeguards surrounding intellectual property and digital creation. Everything from software code and website content to digital music and proprietary databases is protected by laws like copyright, patent, trademark, and trade secret. Your work often plays a crucial role in identifying and tracing the theft or misuse of these invaluable, intangible assets. Eighth, adhere rigorously to the established standards of evidence law when handling and presenting digital evidence. It must meet high bars for relevance, authenticity, proven through meticulous chain of custody and documentation, and often scientific validation, as embodied by tests like Dober in the U.S. Employing forensic best practices like using validated tools, documenting every step, ensuring repeatability, and seeking peer review where appropriate is your shield against legal challenges to your work's reliability. And finally, number 9, remember that international cooperation is absolutely essential in the fight against cybercrime. The ongoing efforts of organizations like Interpol, the framework provided by the Council of Europe's Convention on Cybercrime, and the principles outlined by groups like the G8 nations are all testament to the global recognition that cybercrime requires a unified collaborative response. As a CHFI, you are potentially part of this global network, contributing vital technical expertise to a collective effort against a truly borderless threat.
That's an excellent summary. And this knowledge, as you said, isn't just about passing an exam. It's really essential for conducting ethical, effective, and legally sound digital forensic investigations. It ensures that the valuable work you do actually holds up in court or in an internal investigation potentially anywhere in the world. And that, I think, brings us to the end of another incredibly detailed deep dive. We've definitely untangled some of the complexities of global cyber laws today, and hopefully you, our listener, feel much more informed and confident about navigating the legal environment surrounding digital forensics.
Absolutely. And remember, understanding these laws, these rules of the road, is truly your superpower in this field. It's what allows your technical knowledge and skills to be applied effectively, ethically, and justly. So keep exploring, keep questioning, and definitely keep digging into these fascinating and ever-evolving intersections of technology and law.
We certainly hope this deep dive has given you plenty to think about and process. And perhaps here's a final provocative thought for you to mull over. As technology continues to evolve at, well, lightning speed, fundamentally changing the very nature of data, communication, and our interaction with the digital world, how will legal frameworks continue to adapt? Will today's new cybercrimes like ransomware or sophisticated state-sponsored attacks someday feel as age-old as identity theft does now? And will that necessitate entirely new legal paradigms, new ways of thinking about digital rights and responsibilities that we can barely even imagine today? Something to definitely ponder until our next deep dive.